Hey, everybody. If you've already joined, we're going to get started in about 3 minutes at the top of the hour. Just welcoming everyone and just want to make sure that my voice is coming through and people can see me. So if Laura, I know you're there, could you just send me a message? Tell me if I'm loud enough and if I'm clear, if you can hear me. I'd appreciate that. But we will get going in a couple minutes. Thanks, Laura. Okay. It is 1 o'clock and time to start the presentation. I just want to introduce myself and also just let people know that Laura Hamden is in the presentation. She's the one on the chat. If you're watching the chat, she's helping me to make sure this all goes well. She's going to be putting up some questions and polls. If you would, please go ahead and answer any of these polls so that we can get an idea about who is in the audience and what your needs are, what your thoughts are on these topics. It helps us to focus the topics, and we always make tweaks to the presentation now and then. So any good feedback as to what people want to know more about, or what you really don't care to learn about, or we're just preaching to the choir kind of things. Any feedback like that is really good. So my name is Dan Kraus. I'm an attorney. I'm an author. I've written a book on estate planning called Estate Planning in Wisconsin, which is good because that's where I live and I practice law in Wisconsin. I also practice a little bit in Illinois and a little bit in Minnesota. I'm licensed in both of those states as well, but really Wisconsin is my focus. Sometimes we have clients that cross the borders, and so we can help those people as well. I do estate planning, estate administration, and elder law. So those are very focused areas. They all have to do with becoming incapacitated, dying, and the aftermath. Not really fun subjects, But actually, most of our clients are very glad that they've come in instead of being a bother and a bore. Because even though we talk about death, estate planning is more happy law. Nobody's getting divorced. Nobody's going to jail. None of those things. We're just putting together some paper plans for the future. So let's talk about what is estate planning and why it's essential. So hopefully you can see both me and the slides. The slides are probably the most important part. Also, they're probably better looking than I am. But in case you wanted to see me on the slides, here you go. There's a picture of me at the top. That's one of my photos that they airbrushed so that it looks good. And then on the bottom is a selfie that I took when I was doing some military service, I believe in Minnesota a few years back. Very proud of my military service. I served in the Army Reserves, and the National Guard, all three. Now I'm a retiree. I'm what they call a gray area retirement. Not because my beard is gray, but because I'm not fully retired. I don't get any benefits until I'm 60, but I do have all my retirement points and everything is set up so that I am considered to be a retired officer at this point. Very proud of that service. And if you are also a veteran, thank you for your service. And I do get a lot of appreciation for that. So I really do appreciate people acknowledging that service. Let's see. I'm a specialist in estate planning law. There are 7 of us specialists in Wisconsin and many more throughout the country, but it is a fairly rare specialty. Most people who practice estate planning also do divorces, or they do bankruptcies, or they do commercial real estate. We don't do any of that stuff. We focus on the estate planning. So we're able to specialize. We make sure that we know these narrow subjects a mile deep, as they say. So narrow and deep, and so that we can help people in nearly any situation that they might have regarding estate planning. Also served in the Peace Corps for 2 years, just after college. So along with our narrow focus and deep knowledge, we also belong to many organizations that have to do with estate planning and estate administration, as well as general bar associations, etc. We have many accolades, and our A+ rating with the Better Business Bureau is one of our more proud accomplishments. So, estate planning, what is it? Well, you can read the slide, and I'm not going to read it to you, but essentially estate planning is making sure that you have a plan, a written plan in place in case you become incapacitated, meaning that you can no longer function on your own behalf mentally, or if you die. That's it. Have a plan for if you become incapacitated and can't manage your stuff, or if you pass away and who's going to take care of it and who's going to do it. That essentially is what estate planning is. And now, depending on the way that you put the estate plans together, you can minimize taxes, you can minimize the liability that you or your beneficiaries might have to the tax man, to creditors and predators, etc., depending on how you put things together. A comprehensive estate plan includes at least 3 documents. Now, the documents aren't necessarily the estate plan, but you do need documents in order to have a properly done estate plan. And the 3 documents, the 3 basic documents, are a will, a financial power of attorney, and a healthcare power of attorney. Now, the comprehensive estate plans that we do for our clients have many, many more documents than this, usually a dozen or so documents for each person to sign when it comes time to sign. But these really are the basics, the bare minimum. If you don't have these 3 things, I would say that you don't have an estate plan. You might have done some estate planning, but you have not got a comprehensive estate plan. So those three things. So powers of attorney for finance and healthcare. Now, these are things that can help you in incapacity. So if you age and you get Alzheimer's, God forbid, I hope that you don't, but if you do, or if you get a stroke or an accident or something causes you not to be able to function well mentally, then somebody is going to have to take over your finances. And they're also going to have to take over your healthcare, which we'll talk about in a little bit. But if you don't plan, so if you don't have these documents properly signed and filled out, the state law is going to control what happens to your stuff. And essentially what the state law says is that if you don't have somebody to manage your finances, then we're going to have a court proceeding so that somebody can prove that you're incompetent. And at that point, the judge will decide which things can you do and which things can you not do. And they'll take away your powers to do all the things that the judge thinks that you can't do. And some of those things are banking, marrying or divorcing, having a driver's license, having a marriage license, having a fishing license, voting. These are all things that the court generally takes away from somebody in a guardianship proceeding. And then what they do is they give those powers now to a guardian. So the person who is incompetent becomes a ward, and the guardian becomes the guardian, so that the guardian makes all the decisions, the financial and the healthcare, et cetera, decisions for the ward. Now, this essentially means that the court will supervise your life. Now, it doesn't really supervise very closely. The guardians are required to report every year on your finances and any major health concerns, but generally they just look at the finances, and as long as everything, there's no big red flags, then everything is approved. And what does that mean? It means that somebody is going to have access to all of your stuff, and then they're going to have to report to the court about it. Also, one thing that we do is we help people not lose all of their assets if they happen to go into a nursing home. If you have a guardianship, if you're the ward, the courts will not allow you to do any kind of this Medicaid planning, is what we call it, to save your assets. So you just have to let your assets dribble away in the guardianship until there's nothing left. So who's going to be the guardian if you have a guardianship or you need a guardianship? Well, nobody knows. And it really depends on who's available and who's willing and who fights the hardest for it. Sometimes nobody wants to do it. In fact, that's quite often the case. And then the court has to find somebody that would agree to do it for a stranger. So a lot of times guardians are strangers to the people who are their wards. And most people would not want a stranger watching after their health care or their finances. So you want to use the powers of attorney properly and get good ones to make sure that you don't have to go through this guardianship process. Because if you become incapacitated now and you have these documents, somebody is already there that you've appointed to take care of your finances. Somebody is already there that you've appointed to take care of your healthcare decisions. So if you are somebody that has not gotten a healthcare power of attorney and a very specifically drafted financial power of attorney, then you might be in danger of guardianship or losing everything to long-term care. These are so important. Another thing for planning for incompetence, if you are essentially brain dead and in the hospital, living wills, if you filled one of these out, and it goes along with the healthcare power of attorney, would allow the doctors and nurses to stop treatment and allow you to expire naturally. That's the Terri Schiavo case. About the turn of the century, right around 2000, there was a huge case, and some of you may remember, but the facts on that case are just so sad. Terry was a woman, she was in her 20s and she had a heart attack. And I'm not sure why she had a heart attack or what the reason was, but her brain lost oxygen for long enough that it just never functioned again. But her body was very healthy. She was a very healthy person. So she survived on life support for 15 years before they were able to pull the plug after the case went all the way up to the U.S. Supreme Court. Imagine the expense. Um, Imagine the expense of life support for 15 years. Most people would not want this burden on them or their families and be allowed to naturally expire. So that's why we have the living wills, also another part of a comprehensive estate plan. All right, so let's talk about wills. Now, a will is something that controls the distribution of your assets after your death. It can also appoint a guardian for your children. So if you have children that are under the age of 18 or they are disabled and you are the guardian for the children, you can then appoint the successor guardian if something happens to you, if you become incapacitated or die. Then your will is very important to appoint the guardian. But mostly people think of wills as who gets what upon your death. Now, if you don't have a will, if you don't have a trust, if you don't have a plan written and properly signed, then the state law controls, just like in the guardianship, the state law controls. In this case, it's a probate. So there's laws in Wisconsin in every state, and they're slightly different in each state. So you have to be careful. I'm going to talk about Wisconsin laws. The Wisconsin law says who gets stuff on your death. So you might wonder, well, what's the default? Well, let's talk about that. So if you are a single person, never married and never has any children, and then you die, your parents will get everything under the state law. If you've been married, if you are married at the time of your death and have no children, then your spouse gets everything. If you are married at the time of your death and have children, and all of those children also belong to your spouse, then your spouse still gets everything. Where it gets really hairy and where people really want to be careful, and if this is you, if you have a blended family or mixed family where you have children that are not your spouse's children, or your spouse has children that are not your children, or both, then the state law has a surprise for most people. So what happens if you die and you don't have a plan, a properly written, drafted, and acknowledged and witnessed plan, then half of your stuff goes to your children, half of your stuff goes to your spouse. This is not what most people would want. So it's very important, if you're in this situation, that you come up with some plan. Talk to an experienced estate planning professional and get a plan in writing, because you don't want to die and have that mess where your children are now going to be fighting with your spouse over who gets to control everything. Also, the state law does not allow for the holding of assets past a beneficiary's 18th birthday. So let's say if you die and someone in your family that you want to give assets to, or is your natural heir, is below the age of 18, as soon as they turn 18, they get the millions that you're going to give them. Now, most people don't have millions to give, but they'll get whatever you're going to give them. And 18-year-olds with money, not a good combination generally. So if you write up a plan, you can have them delay their gratification on that so that a trustee can hold it, pay for their college, give them what they need for transportation, but don't just pour it all onto them until they're more mature, like 25 or 30. So the term for not having an estate plan is intestacy. That's a combination of Latin words, like a lot of English is. In means not, testacy means testament, doesn't have a testament, so it doesn't have a will, essentially. Intestacy means does not have a will. So what happens if you're intestate? Then the rules of intestacy apply. And here's an example, James Dean. So many of you may know who James Dean is. He was a star in some movies in the 1950s, kind of a heartthrob, and the, I guess, the icon of whatever was cool at the time. Well, he died at the age of 24 in a car accident. Now, unsurprisingly, a 24-year-old did not have a will. He didn't have any kind of a plan, but unfortunately for him, there were things in his life that would have made it much, much better, I think, if he had had a plan. Now, none of us knows what James Dean would have wanted, but I think we can guess if we know the story. So the story is, when James Dean was about 7 or 8 years old, his mother died. At that point, his father decided, I'm just going to give the kid away to his mother's sister because I don't have time or don't have the energy or just don't have the desire to raise a child on my own. So the father essentially abandoned the child to his aunt. James Dean was raised by his aunt and did not have a good relationship with his father. Now, because of the laws of intestacy in California at the time, similar to Wisconsin laws of intestacy, James Dean was not married. He did not have any kids, so everything went to his parents. Now, he only had one parent living, so his dad got everything, and those royalties and fees paid throughout his father's life, millions every year. And the aunt, of course, got nothing. So now wills are much better than not having a plan, because then you can set out who gets everything and you get to decide who's going to be in charge. However, there are will pitfalls. So what can go wrong with a will? Well, number one, with a will, you're always going to have court involvement after somebody dies in a process called probate. Whether you have a will or whether you have no plan at all, usually the probate court is where everything happens. You have to open up a case essentially where you sue yourself for the benefit of your creditors so that everybody you owed money to can get paid. Now, what sense does that make? Well, it's just the rules. It's how things have developed. And, the people who loan out a lot of money have a big interest in making sure that there's a process for them getting paid if somebody dies that owes them money. So that's all brought into that process. There's also a process that we don't want relatives just bombarding the house and taking everything and just getting into the bank account and taking all that money without some sort of a process. So this is the process that's developed, and it's been developed so that a court or a judge supervises it. Now, what does that mean? It means it's going to cost money. Anything that goes through a court is going to cost money. It's probably going to cost headaches, and it's probably going to cost a lot of arguments amongst the family just because it takes so long, and there are rules and deadlines and time limits and procedures that need to be followed, and it gets dragged out and people get very anxious and just they want it all to be over with. Another thing, and this is getting to be more and more important, anything that goes through probate, like a will, is going to be public. Now, month by month, it gets worse. Privacy concerns get worse and worse and worse because there are people out there, there are machines out there, there are computer programs out there designed to locate money. And if they can locate money through a probate case, which is a public database, then they can figure out who's getting the money and who can we target for fraud, for get-rich-quick schemes, for marriage proposals, etc. So anytime a case goes through the probate court, it becomes public documents, and then your your bots can crawl all through that to see where the money is, who's getting it, when they're getting it, and how everything, financially in your life and your kids' lives proceed after your death. Very, very dangerous, especially these days, for privacy, financial privacy. So in that case, it invites predators. What's the solution? The solution is get a revocable living trust. Set up a trust so that nothing goes through probate, nothing has to be publicly filed. So ever since the 1980s, probably revocable trusts have really caught on. They're older than that, but as far as estate planning type of a vehicle, revocable trusts have really taken off since the 1980s. So maybe about 60 years, let's say. And nowadays, trusts, in our experience, are more common than wills for people to do planning these days. It is essentially a will substitute. You avoid probate as long as everything is properly set up. And once you create the trust, all of your assets are associated with the trust in a proper way. It preserves your privacy and it's controlled by you. Excuse me, I need a little drink. So it's controlled by you, meaning that during your lifetime, you can do whatever you want with the assets that are in your trust. You spend them, give them away, you buy, sell, barter, etc. You can change your trust. You can change what it says, who gets things on your death, who's going to be in charge after you're gone. All that's changeable during your lifetime. But the big deal is there's no court involvement and no public filings after your death. Now, the will substitute type of a trust is a revocable trust or revocable living trust. Now, there's several types of trusts, but two categories are revocable and irrevocable. Irrevocable trusts are not quite as common as a revocable trust, but they also have their uses, and usually the reason that they're used are for tax planning and for avoidance of paying certain amounts to certain people. Now, that's asset protection. So asset protection trusts come in many different flavors. Some of them are to avoid the liability of lawsuits. Some of them are to avoid the liability of divorce. Some of them are designed to avoid the liability of long-term care costs, like nursing home costs and assisted living costs. So if you have an estate plan, you can have a will and a revocable trust, but on top of that, you can add an irrevocable trust to protect some of your assets. We never recommend that you put everything in an irrevocable trust. It just doesn't make sense. It's not feasible, and we can talk about that in your particular case if you are concerned. If you're concerned about somebody suing you, if you're concerned about your kids losing the money that you're going to give them because they get divorced, if you are concerned about losing everything at the end of your life because of nursing care, then an irrevocable trust is something that you should talk with your trusted estate planning attorney about, because it might just fit your situation and save you hundreds of thousands of dollars potentially in many cases. All right. Now, there is concerns. There are many concerns with not only what's going to happen with your assets when you die, but to the people who are going to get them. Is it going to cause them extra problems? Is it going to cause them liabilities, etc.? So specifically for disabled people, if you have a disabled child, you need to really make sure that your estate plan does not pass on money directly to that child, but puts it instead into some sort of special needs trust. Excuse me. So disabled people inheriting money can be dangerous for them because they may have spent most of a year applying for Medicaid, applying for SSI so that they could get this government help. And then now they've got an income. Now they've got a safe place to live. Now they've got money for food, clothing, and shelter. And then your inheritance hits them. Now they get knocked off of all those benefits. They have to spend your inheritance. And then when it's all gone, they have to go through the process of applying for those benefits all over again. Now, wouldn't it be nice if there was some way that they could keep getting their benefits, plus also have the benefit of the assets that you want to give them? Well, there is a way. The way is called a special needs trust, or also called a supplemental needs trust. Those are the same things. Some people call them special needs. Some people call them supplemental needs, but they both do the same thing. It's the same type of trust. There's also ways that you can protect your kids and their inheritance from if they get divorced later on, or if somebody sues them, or if they happen to go bankrupt after you give them money. We've seen cases where a parent dies. Unfortunately, at that point, the child was going through bankruptcy. So the $150,000 that was going to that child went right into the bankruptcy and was given out to their creditors. It was a sad, sad thing. They all the parent would have had to do was create a beneficiary protection trust for that child so that the money goes into the trust and not directly to the child. And that child would have had $150,000 that they could manipulate and manage and use for their benefit without losing it in the bankruptcy. So the bankruptcy could wipe out all their other debt, and then they've got this chunk that you've given them to start with. So if you're concerned about your kids getting divorced and losing half of everything that they've got, if you're concerned with your kids going bankrupt, if the economy goes bad, or if they have medical bills, then you should consider giving them a trust instead of just giving them naked assets. So when people die, mostly the kids get naked assets. So they just get a check, or they just get some real estate and they put it in the child's name. And now that asset is the child's, and it's liable to pay any creditors, any bankruptcy, any divorce judgment. But you can change that if you do proper planning. Let's talk a little bit about estate tax. Many people use estate planning to plan for an estate tax so that they can maximize their money that goes to their kids and minimize the amount that they have to pay in the estate tax, or some people call it the death tax. Now, I want to point out, very few people need to worry about it. But if you are somebody that has more than about $7 million, or you plan to have at least that much at your death, which, all of us should plan for that, but very few people actually do have more than 7 million at their death, less than 1% of the population. It's not a very big problem. So when people try to scare you about the estate tax and the death tax and get you worked up, oh, the government's going to grab all your stuff when you die, it's mostly not true. It's only true for people that have more than $7 million. In fact, this year it's 13.61 million. The reason that I say 7 million is because it's going to go back down. The number that the 13.61 million is an exemption that exists in 2024. In 2025, that's going to go up a little bit for inflation. So it'll be around 14 million, maybe a little over 14 million. But then, unless Congress changes it, 2026 is going to drop down to approximately 7 million. We don't know the exact number yet because it depends on inflation. So the high estate tax exemption sunsets at the end of 2025. So we tell people, plan on about $7 million. If you think that you and your spouse are going to have more than $7 million at your death, then you should talk to your estate planner about estate taxes, because it's a heavy tax. So you take out the exemption, $7 million, and anything over that, you're going to pay 40% of estate tax as it passes or before it passes to your kids. Another thing about that, especially if you have farm property or a valuable business, because the estate tax has to be paid within 9 months of the death in cash to the IRS. What are you going to do if you have a farm? How are you going to raise that kind of money if you owe, $1 million to the IRS? How are you going to get that? You're going to have to take out a big loan against the farm, or you're going to have to sell it or something, especially if the farm is going to 5 children. There's no way that you're probably going to get away without having to sell that farm, or at least a good part of it, in order to pay the taxes on that. So those are things that you need to talk to your estate planner about if you have a really valuable estate. Now, more people than have $7 million are going to have a nursing home expense issue. Thousands and thousands of people every month die having nothing because of the cost of care at the end of their life. People expect that they put together their nest egg and they save well enough and they've got their home paid off. They may have a vacation property up north, and then they figure their kids are going to have, something nice when they die. But in so many hundreds of cases, it doesn't happen that way because nursing homes get in the way. Assisted living, nursing homes. Most people cannot afford to pay month by month $14,000 for nursing expenses. And that's about what it is these days. It's about $14,000 per month if you're in a nursing home. Where does that money come from? Most people don't realize until they hit the 60s and maybe 70s that the money comes from their pocket. So in order to prevent the money coming from your pocket, there are certain things that you can do. But first, let's talk about asset protection and nursing home costs. So you can do nursing home expense planning. And nursing home expense planning, the bottom line is you plan to take advantage of Medicaid to pay for your nursing costs or your assisted living costs or your home care cost. And you plan to have your assets set aside so that they can be there for your security during your lifetime. And then some of them can pass to your kids after your death. So there's 2 types of planning that we have. We divide things a lot of times, and this is divided from pre-planning and crisis planning. So the pre-planning that we do is because of the rules of Medicaid qualification, there's a 5-year look-back period. So in order to get rid of your assets or put them in a way that cannot be counted against you, you have to do it more than 5 years before you might apply for Medicaid. Otherwise, you're going to get penalized. So when people are relatively healthy and relatively young, say 60s, 70s, sometimes early 80s, you put stuff aside and then you're just careful for the next 5 years and try not to need any kind of nursing care. Now, of course, all of us are hopefully very careful not to do anything that's going to cause us to need nursing care. But that 5 years period is very important in the pre-planning. The crisis planning is when somebody is needing to go into a nursing home or assisted living now, or maybe they went a year or 2 years ago, but they still have money left. You can do a crisis plan, and as long as they've got $150,000 left, it's going to make sense to do one of these crisis plans to try to save some of that, half, sometimes more than half, for the family, so that you don't watch it all just dribble away. So that $150,000 is a rough number, and that's where we've found out that it makes a lot of sense to do this kind of planning. It's expensive planning, but in the end, usually the family saves quite a bit more than if they had done no planning at all. Okay. Now, some people say, oh, you want to get Medicaid to pay for your nursing care. That's not fair. While most people go broke paying out of their pocket. Why should you be special and your family gets to have Medicaid, a government program, pay for your care? And my answer is discrimination. So let me explain what that is. If you're old, imagine that you're 83 and your brother or sister is 82. Now, each of you gets a different disease. One of you gets cancer, one of you gets Alzheimer's disease. Now, the way that your health care is going to work from the time of that diagnosis is going to be very, very different just because of which disease that you have. This is wrong. It's morally wrong. It's a bad choice of government. Now, it's not illegal to discriminate based on disease, but it's nobody's choice to get cancer or Alzheimer's. And guess which one is going to cost you your entire life savings? Alzheimer's disease, Parkinson's disease, other types of dementia, etc. If your care is going to be long-term care in a nursing home or assisted living facility, you need to go broke before the government program is going to step in and start paying your bills. On the other hand, if you're lucky enough, now I don't want to say that people with cancer are lucky, but financially, compared to the Alzheimer's patient, a cancer patient is very, very lucky because they automatically get Medicare. They don't have to pull out of their pocket for anything. Medicare is going to pay the maybe $1 million, could even be $2 million in care costs for cancer care, cancer treatment. And then their Medicare supplement is going to pick up the rest. They don't have to pay out of pocket except for the little bit of insurance costs. So they can pass on their house. They can pass on their life savings to their kids if you have cancer. But if you have Alzheimer's disease, no such luck. So we don't mind. In fact, we think it's a great service to help people to avoid this discrimination by allowing Alzheimer's patients, people with dementia or other, maybe just feebleness of old age, if they need treatment in a long-term care facility, we want to help them get the government benefits that they deserve, that they should get, just like a cancer patient would get. So what's the government's plan? Now, we talked about, the government's plan versus your plan and what your plan should be. So the government has a plan for you. If you don't have a plan, you've already got one by the government. So the government's plan is if you have Alzheimer's disease, you need long-term care, you end up in a nursing home. Their plan is you spend down everything except you can keep $2,000. You can keep your home, which is nice. You can keep your car and burial insurance, and you can keep the contents of your home, pots and pans and furniture, etc. Everything else has to be spent on your care. And then you can qualify for Medicaid to pay for your care. Now, a lot of people say, hey, my home is my biggest asset. If I can save that, that's good enough. The problem is the second part of the government's plan is called estate recovery. So if you die while you still have a home, after Medicaid has paid for your care, the government comes and they put a lien on your home and then they take it to repay Medicaid. That's the estate recovery system. Now, if your home is in a revocable trust, if your home is in an estate, any kind of an estate, if it's passed through your will, if it's jointly owned and it passes that way, government doesn't care. They will put a lien on that home and they will force a sale to take back whatever they paid. So essentially, the government's plan is you pay until you have nothing, and then you have no ability during your lifetime to have any money for your security, just so that you can feel like you have some money, some power, some abilities. You get none of that. And then after you're gone, your kids get nothing either. Your plan. What should your plan be? Well, if you don't want to end up at the end of life with nothing at all, completely reliant on the government, you should make a plan where you keep your house for your kids and the farm. You keep the farm for the kids, and you have money and assets set aside for your security in case something happens to you and you need to be in a home. At least your family can have this money, these assets that they can support you in a way that people who are completely reliant on the government are not supported. So we've gone through a lot. Now, I do want to make very clear that it's not cheap to do proper estate planning. This is a question that a lot of people have. What does it cost to do estate planning? Now, if you're going to do a basic plan, and if you're going to do it with a specialist, somebody that knows what they're doing and can make sure that everybody is taken care of, for a single person, that's going to start off around $2,600. And it can go up, depending on whether you want trust, whether you want Medicaid planning, it can go up to over $8,000. The planning for couples typically are about $500 to $1,000 more than the planning for a single person. Couples are able to plan for less than double of what it would cost for a single person. I can't tell you exactly what it would cost in your case, but I can tell you that usually the peace of mind and the benefits for your kids are going to far outweigh any price that you might pay for these plans. So now I want to go back and see what questions people have. Apparently, Laura has identified 3 questions, and so I will go through those. If you have further questions, please put them in the chat, and then we can address them in the next 15 minutes because we're done at 2 o'clock. All right, so first question is, what is the default in probate if there is a blended family? Okay, so I think we talked about that a little bit. What the state law says that if you have a spouse when you die, and you also have children that are not the spouse's children, then all of the individual assets of the person that died get split, half to the spouse, half to the children of that person. Now, if the person who died had children that did not belong to the spouse, plus they had, let's say, a child that was also the spouse's children. So let's say they had 3 children, 2 before that marriage and 1 during the marriage. All 3 of those children get equal. They all get to be part of that half that doesn't go to the spouse. And then all of the assets that are considered marital property, the spouse keeps their part of the marital property that already belonged to them. And then all of the marital property that belonged to the deceased spouse goes to their kids. So essentially everything gets divided half and half, unless you've got a plan, unless you've got a will that gets around that, or a trust, even better. All right, let's see. Did that message get deleted? Because I don't see it again. Okay, maybe Laura is deleting them once I've looked at them. Please let me know. All right, so the next question, will there be an inheritance tax or other taxes to be paid on assets put in a trust by the beneficiaries? Well, an inheritance tax or an estate tax, we talked about that. And it really depends on what type of a trust. An irrevocable trust can take assets out of your estate for estate tax purposes, but the irrevocable trust can also leave those assets in your estate for estate tax purposes. And there's advantages either way. I think that's probably too complicated of a question to really drill down on it in this time period that we have left. But the normal trust, the revocable living trusts that we do don't really have any tax consequences any different than if you just did not have a trust. If you just had a will, or if you had no plan at all, your taxes aren't going to be any different. The irrevocable trust, though, can make a big difference in your estate taxes and other taxes like capital gains taxes, etc. All right, question. If there's a payable on death associated with all bank accounts, would those be excluded from potential probate? So here's the question about PODs on accounts. There are many reasons that people do estate planning. One of those many reasons is avoiding probate. So they do trusts. If you put POD on everything, and you're lucky enough so that your family doesn't change and nobody gets disabled and nobody dies early or anything like that, if you're lucky, then you can avoid probate with POD and TOD designations. However, you can't plan for an accidentally disabled beneficiary. You can't plan to have somebody under the age of 18 have to wait until they're 25 to get those assets. You can't have contingency. If something happens to this person, then it goes to that person. If something happens to that person, it goes to that person. Also, the big problem that we see with people that do PODs and TODs. I know that bankers love to tell people that they should do this, but you should not. Do not do POD and TOD on everything. People get the idea, oh, we can avoid probate. That's true. Sometimes you can avoid probate, but the problems that you're going to leave your heirs are big headaches. Imagine you got 3 heirs and then you do POD and TOD on everything. Now you've got a piece of real estate or some debts that you had, your final hospital bill, etc. Now all the money is gone. There's nothing in the bank. There's nothing in your investments. There's nothing. Now they have to chip in, and there's always going to be one that refuses to chip in. So you've left a mess that nobody has control over if you do POD and TOD on those accounts. It's a mess to keep track of, and I don't recommend it. But the answer to your question is, if you're lucky enough, you've named the right beneficiaries, nothing happens to them, they don't become incapacitated, they're not in the car with you when the car crashes, anything like that that could just wreck that whole plan. If none of that happens, yeah, you can avoid probate, but I wouldn't count on it. You're rolling the dice. Okay, is life insurance a good way to ensure money goes to those you want? People would think so. However, if you are an aged person that needs nursing care, they will not allow you to keep paying on a life insurance policy. So in that case, no, unfortunately. Also, if you do have a paid up life insurance policy, they make you cash them in order to pay for your care before Medicaid will pay. So life insurance is not always a great way. If you have a lot of money, life insurance, and even combined with an irrevocable trust, can be a great way to pay the estate tax. If you have more than $7, $8, $9, $10 million, taking out life insurance to pay that estate tax so you don't lose the farm or have to sell it, great idea. Something that you should talk with your person about, your estate planner. Okay, let's see. Oh my goodness, got a lot of questions here. If a person with Alzheimer's needs memory care, how are spouses' assets protected? All right, that's a very complicated question. I'm just gonna say, if there is a case where you have spouse, a married couple, and one of them needs care and the other one doesn't, oftentimes both spouses become impoverished. But if you get the right attorney, if you come to our office and you're in Wisconsin, we can save everything. The nursing homes won't tell you that this is possible. The county will not tell you that this is possible. Well, we do everything above the board. We follow the rules. We know the Medicaid rules, and we use them in our clients' favor, not the nursing home's favor, not the memory care facility's favor, and not the county's favor. So how are they protected? Well, there is some protection, and you can save $154,000 But if you've got more than that, you really need to be able to save everything. And we can help you do that. What if no kids, but 3 nieces and nephews? Does it work the same way as if they were your kids? I'm not sure exactly what you mean by that. If you're talking about if you don't have a plan, do your nieces and nephews get stuff? I'm not sure I understand that, Maureen, what the question was. I guess I don't know how to answer that. The question, if I'm legally separated in Wisconsin, does my legally separated spouse get my assets or does my child? That's a good question. And the answer is, it depends on what the legal separation says. It's going to be a judge's order, and that should be considered in the judge's order. If it's not, then as long as they're your legal spouse, they will get the legal spouse's rights to the property. Okay. Can an already established trust and POAs, where are we? And POAs established in different state flow through to Wisconsin with a change of residency? So I can tell you that if a power of attorney and a trust is legal in the state where it was created, and that's an if, I don't know what the answer to that is. As long as they were legal in that state, they're legal in Wisconsin. However, they may be treated differently in the way that they're effective in different states. Okay, so the state is going to determine what the law is. The POA is legal, but can it be used in all the situations that it could be used in the other state? Maybe, maybe not. So documents do not lose their legality when you move to a new jurisdiction, but they might change their effect. So let me give you an example. One that we come across sometimes is that in Florida, there's a law that if you're going to use a power of attorney to buy or sell real estate, the power of attorney has to be witnessed by 2 individuals. So the Wisconsin powers of attorney that we do are perfectly valid for every purpose if we have a notary on there and no witnesses. Well, the notary is a witness. It's a type of official witness. But if somebody takes a Wisconsin power of attorney and tries to transact business in Florida with real estate, it will get denied. Okay, so things can work that way in reverse when you come to Wisconsin as well. I can't think of an example right off the top of my head, but that's a general reason why you should have new documents in a new state, or at least have them reviewed to make sure that they're going to work. Okay, will there be an inheritance tax or other taxes to be paid on assets put in a trust by the beneficiaries? I think we talked about that. How do I transfer things? These keep changing. I think Laura's deleting them, and now I can't find which ones I'm looking at. Will there be an inheritance tax? Okay, saw that one. How do I transfer the deeds of my property, avoiding probate? Well, you deed your property into your revocable trust. That will avoid probate, and it will also take care of a lot of other things. If you're concerned about nursing costs, then you would deed your property into an irrevocable trust, and that would be your best bet. Can you explain what spousal protection is? Spousal protection in regards to Medicaid law is the protection of certain assets for your spouse. The spouse is allowed to keep all of their income, but there's a lot of rules about this, but if your spouse needs care in a nursing home and you don't, you get to keep all of your Social Security. You might get to keep some of your spouse's Social Security. If your income is under $3,200 a month, then you can keep some of your spouse's. You can save some of the assets like that. But then you have to spend everything, and it depends on what you're allowed to keep depending on what you started with. So if you start with over $310,000 in countable assets, so bank accounts, investments, etc., then the spouse that doesn't need care gets to keep up to $154,000 of that. So you have to spend down, you still have to spend down half of everything, essentially, at least half. Unless you have less than 100,000, then you get to spend down less than half, because the spouse is allowed to keep a minimum of 50,000, but a maximum of 154. Unless you do planning. If you do planning with us, you can keep it all. Okay, is your paid off house probated if you have a will? Yes. Yes, it is. Unless you own it with your spouse and your spouse survives. If you've got a jointly owned house, it doesn't have to probate on the first death. Is your spouse responsible for any and all medical expenses should you die? Yes, your spouse in Wisconsin is responsible for medical expenses. Let's see. We are coming to the end of the hour. Let me just look through here. I'm probably not going to get to all these questions. Can you explain what spousal protection is? If you put your property as transfer on death, you still need to do probate. If you put your property on transfer on death, it's the same as POD. You will not save it from the Medicaid lien. The state will take it to pay your nursing costs. But if you don't have nursing costs and you put a transfer on death deed on there, you can avoid probate on the house if you do that properly and you're lucky enough that your beneficiary on the POD or TOD deed is living and not disabled. Are IRA and 401k accounts included in the dollars that government can tap if you go in a nursing home? Yes. IRAs and 401ks are countable assets and they're expected to be spent. In fact, even any cash amount in a life insurance policy, if you have a cash value, they expect you to spend that. They expect you to spend everything, essentially. Now, if your spouse needs care, your 401k and your IRA can be shielded, but theirs can't. If you're a single person, everything is up for grabs except for the house, one car, and then they take that after you pass. Okay, are trusts better than wills? In almost every case, yes. So the question is, are trusts better than wills? Yes, they are. They're easier. They are, your kids don't have to go into court. They can do everything at their kitchen table. Nothing becomes public record. You don't have web bots crawling through all the public records looking for money and discovering your will going through probate, etc. Thank you for your services, Veronica. Well, it's really an honor. I've been honored to be able to serve our country, and I do appreciate your recognition of that. All right. I hope that you've gotten a little bit of value from this. I encourage you to do estate planning. You don't have to do it with us, but if you want to, there is a form that I think Laura shared or a link that you can set up a consultation. Keep in mind that it's not for everybody. It does cost money. There are cheaper ways to do this. There are other estate planning law firms. We do think that we offer great value for the money, and we don't know of any other firms that do a better job than we do. I hope that you will do some estate planning. I wish you the best, and I will sign off. Thanks, everyone.